Hello everyone, welcome back to our channel. This session is going to be about CA Final Self-Paced Online Modules Set A Corporate and Economic Laws. In that, Company Law, Chapter number 9, Adjudication, Special Court, NCLT and NCLAT. We are going to see this chapter in this video, and whatever the notes I am using in the video, that will be available in our website. The website you can log in freely and then you can download the notes. Now I will show you how to log in into the website and download the notes. Now here in the browser you can type Mission CA Virtuals and then you can see the first page which is opened, and here you can click on it. Now here if you see, you will see this tab, CA Final SPOM free resources. When you go into that, you will be able to find all the SPOM resources. Set A, Set B, Set C, Set D, everything will be there. Instead of scrolling through Telegram channel, word messages and all, you can just come here and then find these resources. Just you have to log in into the website, then you can access the resources for free. So all the YouTube channel links, YouTube videos links, and then the resources PDF, everything will be uploaded here. Inside the Set A folder, it will be available. So you can easily come into this website, log in with your mobile number, and then view the PDF resources. So now we can start the chapter. Now we can start the chapter number 9, Adjudication, Special Court, NCLT and NCLAT. So first we can see about NCLT and NCLAT. So we can add one page here. So we are having the NCLT. NCLT means the National Company Law Tribunal. And we are having NCLAT, which is the same thing, but appellate tribunal. So this is the meaning of NCLT and NCLAT. These are all quasi-judicial bodies. Quasi-judicial authority, meaning that they are in the judiciary only, they are in the court-like system only, but they are not having the same power like court. Some power may be there, but they are not completely courts. So that is the meaning of tribunal. They are like court, but it is not completely like a court. So it is called as a quasi-judicial authority. Partly it will be like a court. You will get a court-like feeling when you are dealing with the NCLT and NCLAT. So first your case will go to the tribunal, and if tribunal makes an order and you do not like the order, you want to go for an appeal. So then you can go for an appeal with the NCLAT. So that's why it is called as the appellate tribunal. Now we can see NCLT and NCLAT one by one. First, when you see NCLT, here we are having one president and then judicial and technical members. In NCLT, we will have the president, and then the judicial member, technical member will be there. But when you see the NCLAT, we will have the chairperson. Along with it, we will have other judicial member and the technical member also. So that information is given here. Now, the next thing, when you see order of the tribunal, when the NCLT makes an order, what is the order that we are going to see here? Before making the order, they will give a reasonable opportunity of being heard. Before passing order, they will give everyone to give their argument. To place their argument, they will give an opportunity. Then, after making an order, tribunal can make any amendment in the order. What is the amendment? For any mistake that is apparent from the record. When you see itself, you can see that there is a mistake, like some date mistake, some calculation mistake, some percentage mistake, like that. Some mistake which is apparent from the record. When you see the record, you will be able to point out the mistake. Such mistake they can rectify, they can amend within 2 years from the date of order. So, amendment 2 years. NCLT order, if you want to amend, you are having 2 years time. Then the amendment they can do only if the case is not in appeal. Now NCLT gave the order. Now you went for the appeal. The appeal case is pending before the NCLAT. Now, since it is pending before the higher authority, NCLT now they cannot interfere and do the amendment and all. Only if the case is normally there, only then they can do the amendment. If it goes for an appeal, then they cannot do the amendment. So that is this point. When they make an order, they have to send the copy to all the parties concerned. Then, after you are going to the appeal, what will happen when you are going to the appeal? You are a person agreed, you can go for an appeal. Then, you are having one more type of order. When the NCLT is making an order, they will ask you whether you are having the consent. Whether you are having the consent to the order. Do you agree to pass this order? They will ask you your consent. If you provide yes, then you cannot go for an appeal. But if you provide no, I do not like this order, if you tell like that, you can go for an appeal. So that is the point. next point, when you see what is the time period for filing the appeal, 45 days, which is the normal time limit. And if you have proper reason, the NCLT, appellate tribunal can allow you to file the appeal, even after such further period. That further period shall be not exceeding 45 days. So, originally 45 days time period you are having. If NCLAT sees that you are having some proper reason for not filing the appeal within the 45 days time limit, they can give you an extra 45 days. Only this much is the extension that can be given by NCLAT. So this is the time limit for appeal filed to the NCLAT. In the same manner, NCLAT will also give an opportunity of being heard, and then they will either confirm the order. They will say that the order passed by NCLT, that itself okay, there is no problem. Or else they will modify the order. They will do some changes. Or else they will set aside the order. They will cancel the order. Then the order of the appellate tribunal, that also will be sent to all the parties, including NCLT. Now the next point, when you see expeditious disposal, when a case comes to NCLT or NCLAT, they have to try to complete it quickly. They should not prolong it. So they should make the full effort to dispose the case as soon as possible. Within 3 months they have to dispose it. So both NCLT and NCLAT, the case disposal, when it is coming to them, it should be done within 3 months. Now, reasons to be recorded for delay. If you are taking more than 3 months to settle a case, then you have to record the reasons in writing. Then, this is the time limit, 3 months. How much extension they can give? They can extend by 90 days. So, 3 months plus 90 days. Extra extension is 90 days. For this, why you are giving the extension? That reason you have to record in writing. The tribunal should record in writing. So that also is there. Next, if you want to go more than NCLT you done, then also you did not get the order in your favor, you can go for an appeal to Supreme Court. But you have to go to the Supreme Court only in case of question of law. If you're having any problem with the law, you're not having any problem with the facts of the case. Facts of the case you have to establish in the lower tribunal itself. Up to the NCLT, you can go for facts of the case. Any problem in the question of facts. But if you want to go to Supreme Court, you should be having a question of law, so that you can go within 60 days from the date of receipt of the order. Then within 60 days, if you are not able to file, you can get an extra time period of 60 days. That also from the Supreme Court only, if you show the proper reason. So from NCLT, you can go to Supreme Court. You are having initial time period 60 days, and then extra extension can be, you can get 60 days, and this 45 days, 60 days, this is the discretion of the tribunal or the Supreme Court. If the NCLT thinks that you are having proper reason, then only they will give the extension. If they think that there is no proper reason and all, you are negligently delaying the case, then they will not give you the extension. So that also you have to keep it in mind, and you can go to there only for question of law. So these are all the important points when you see the NCLT, NCLAT, Supreme Court, and then this is the members of NCLT, NCLAT, the time period for disposing the case. Done. We have completed the Supreme Court also here. Then procedure for tribunal and appellate tribunal. Normally when a court is hearing a case, they will see the procedure under Code of Civil Procedure. As per that only they will conduct the case and all. But for tribunal and appellate tribunal, this code will not apply. They can create their own procedure. That is given. What are all the powers that are there with the tribunal? All the powers that are there with the civil court, the same powers will be there with the tribunal. What are all the powers? Summoning and enforcing the attendance. You are compelling someone to attend the case, to appear before the tribunal. Requiring the discovery and production of documents. You can ask some person to produce the documents. You can get the evidence on affidavit. You can request the public record or document from any government department. Then issuing commission for the examination of witness. You can appoint a commissioner. He will go and do small inquiry, or he will get the evidence from the witness and he will produce it to the court. Like that, you can appoint a commissioner to do the administrative work and hearing of witness. Then dismissing a representation for default or deciding it ex parte. So ex parte means when you are not going to the court, they asked you to appear, but you did not go to the court personally on that hearing date. Then they will pass a ex parte order. You did not come because of your absence. They will pass the order against you. That is called as ex parte order. Dismissing a representation for default. For example, they gave you 1 month time to file a reply, but you did not file the reply. Because of that, even after 1 month, if you go and file the reply, they will not accept the reply. That is the meaning of dismissal for default. Within the time limit, you did not give the reply, so they will not accept your reply if you are giving it late. Then setting aside the order of dismissal or ex parte. For example, a lower court or a lower authority, they dismissed your reply because you did not file it on time. That order can be cancelled by the tribunal or the appellate tribunal. That also they have given. Then any other matter like this, these are all the powers that are there with the tribunal and then the appellate tribunal. Whatever is the order made by the tribunal, appellate tribunal, they will send it to the court, and then that court will do the execution. As if it is an order of a court, they will execute it in the same manner. Implementation will be done in the same manner. Then, in which court it will go? The tribunal passes the order. Now, to which court it will go? The company is there, right? In Companies Act, all the offence will be related to companies only. The company registered office will be there in an area. For that area, whatever is the relevant court, to that court they will send the or tribunal order. Then, whatever the proceedings that is happening in the tribunal and appellate tribunal, it will be deemed to be judicial proceedings. That is also considered in the rank equivalent to the judicial proceedings happening in all other courts. Then, if you do not follow the order of tribunal or appellate tribunal properly, then it will be taken as contempt of court. Normally, when you, what we can say, disrespect a court or you did not follow the court instructions properly, they will take contempt of court and they may arrest you also. So, the same rank we are having for tribunal and appellate tribunal also. Their order also have to follow properly as if you are getting an order of a court. Then tribunal and appellate tribunal, they can direct some persons, some officers, employees, delegate some work to them. They can apportion some work to them and then ask them to do inquiry and report to the tribunal directly. They can appoint some officers to do the work of the tribunal. Then the officers, employees, tribunal, president, chairperson, if they are doing something in good faith, they want to carry out the purpose of the act, they want to do their work. For that, if they are doing, and because of that, you suffered some loss, you cannot do a case on the president, chairperson, and all, they caused me loss. That all you cannot tell. No proceeding can be done against these people for doing their work in good faith. Then, when the tribunal or appellate tribunal thinks that they want to take into their custody some books, properties, or other documents, they have to take the assistance of chief metropolitan magistrate, chief judicial magistrate, district collector. They cannot go into each and every district everywhere and then they can do that. They have to take the help of these people. The property is located in some place. In that area, the relevant metropolitan magistrate, judicial magistrate, district collector, they will be there. The tribunal will send a request to these people to take into custody the property, books of accounts, or the documents. The collector will take it into his custody. Then, whatever the thing done by the collector, as per the instruction of the tribunal, you cannot do a case on the collector. The collector did wrong. You cannot start any case on the collector for that. So that also is there. Then, civil court not to have jurisdiction. If a matter, in that matter, tribunal or appellate tribunal has the power to decide that matter, then civil court cannot take up that matter for any case. They cannot start the proceedings on that matter because tribunal only can start the proceedings on that matter. Then, if there is any problem in the constitution, we saw that president should be there, judicial member, technical member. For them, the qualification, experience, everything will be there. For example, one judicial member, he is there in the tribunal, but he is not having the relevant experience or qualification. Somehow he got into the tribunal and he is deciding the cases. Immediately, you cannot, once you get to know that, you cannot go and say that whatever the cases handled by this judicial member, whatever the cases in which he handled it, he was a part of the tribunal when the case was being heard. Now, you cannot say that those cases are invalid just because of the problem in the judicial member qualification. So that you cannot question the you cannot question the validity of the proceedings just because of a problem in the constitution of the tribunal. So this is a normal point only they have given here. Then here one more point, when you see no injunction shall be granted by any court. Injunction means stopping the work. Like for example, something is happening, you want to go to court and then get a prohibitory order. They should not do the work, they have to stop the work. Like that, if you want to get an order, they cannot get it against the, what we can say, tribunal or appellate tribunal. If tribunal is passing an order and that order is being implemented, you cannot go and get an injunction order against the tribunal order. So that is there. Then, right to legal representation. A person, if he is asked to appear, they can appear directly or they can appoint a chartered accountant, company secretary, cost accountant, or lawyer or advocate. They can ask them to appear. They can appear through an authorized representative. They can send these people to appear on the behalf of the person. Then Limitation Act also will apply. Like that, these things are there. Now, this provision, when you see, this is transfer of certain pending proceedings from the old Companies Act, and before the NCLT, we had the Company Law Board. From the Company Law Board, all the proceedings should be transferred to the newly established National Company Law Tribunal. For that, they have given one provision. You can read by yourself. That is not that much important. So that's all about the NCLT and NCLAT. Now we can start the topic of special court. So here, special court is a special court which they have established for the speedy trial of offences. For completing the trial quickly, they have to complete the trial and award the punishment or penalty or release the person quickly. For that, they have created the special court to reduce the burden on the session court, high court. They have created the special court for the specific purpose. Now, if the offense, the imprisonment is 2 years or more. The offense involves imprisonment in the punishment and then the punishment is 2 years or more imprisonment. Then you have to go to the special court and then the single judge, who is a sessions judge or an additional sessions judge, will be the person hearing the case. Imprisonment 2 years or more, then this person will be hearing the case. In other offences, metropolitan magistrate or judicial magistrate of first class will be hearing the case. So, based on the seriousness of the offense, if it is a serious offense, you have to go to the first category. In case of other offense, you can go to the second category. Then, these persons, the single judge, additional sessions judge, metropolitan magistrate, these people will be appointed by the central government by consulting with the Chief Justice of High Court. Now, the next point is offences triable by the special courts. So, the company is there, related to that some offences there. The area where the registered office of the company is there. In that area, whatever is the special court established, that special court will hear the case. If there are more than one special court in the area, then High Court will give you the direction to which special court you have to go. Then, if you are accusing a person, you are placing allegation on a person, you are telling that that person has did a wrong thing, then you have to give that complaint, and then that person will be forwarded to a magistrate. If some person is accused, then that person will be forwarded to a magistrate accused of doing any offence under this act, Companies Act. Then we will forward that person to a magistrate. If the magistrate is a judicial magistrate, then they can give 15 days detention. Detention means the person will be under the custody of the police and then they can do some inquiry or get the evidence from them. Like that, they can do that. That is the meaning of detention, and that can be granted for maximum 15 days by the judicial magistrate. And if it is an executive magistrate, they can grant maximum 7 days detention. If the magistrate thinks that such a detention is not needed, then they can forward the case to the special court. Special court, they will have the same power as the magistrate and they will decide what they have to do. Then special court, they can read the police report and then they can act upon a complaint also. Even if you do not bring the accused to the special court, upon reading the police report or after getting a complaint, the special court can take cognizance of the offence. Like take cognizance means they can take notice of the offence and then they will start to do the trial for the offence. So even without producing by the magistrate, if they read the police report, they get to know about it and they are getting a complaint. In that case, they can take cognizance of the offence. They can start to do the trial for the offence. Then, if a person has two or more offences, one offence is under the Companies Act, two or more other offences is on the other act, then the special court can conduct the trial for all the offences together, may also try an offence other than under this act together. Then, summary trial, we are having two types of trial. Here we can add one page. So, before that, till now what we saw, we can just write the important points. So, if it is a magistrate, if it is a judicial magistrate, then they can grant maximum 15 days detention. If it is an executive magistrate, they can grant maximum 7 days detention. Now, if they think that detention is not needed, then they can forward to the special court. Then we are having two types of trial. One is the regular trial. Normally the case will be conducted, that is a regular trial. Next one is summary trial. Summary trial is for unserious offences, like small offences, where lower imprisonment is there. In that cases, summary trial will be conducted and they will try to complete the case quickly. That is what they have given here. In summary way, they will conduct the trial, where the offence, the maximum imprisonment that is there, right, that is for a term not exceeding 3 years. The imprisonment for the offence is not exceeding 3 years. The original imprisonment. Original imprisonment is up to 3 years. Then they can conduct the summary trial. After conducting the summary trial, they can give the punishment, right? The punishment they can give maximum 1 year only. Original imprisonment is up to 3 years. Final punishment, they can give imprisonment up to 1 year. So if you go under summary trial, imprisonment up to 1 year only they can grant to you. Then, after hearing the case, the tribunal, not the tribunal, the special court, thinks that this is not possible, they have to give more than 1 year imprisonment. Then what they will do, or due to any other reason they think that summary trial will not be proper for this offense, then they will convert it into a regular trial, and normally it will happen. Here there is no maximum limit for imprisonment and all. So that is also given here. Summary way for this thing: original imprisonment up to 3 years, conviction, punishment, final punishment they will give maximum 1 year only. If they think that it is not proper, they will send to the regular trial. Then appeal and revision, you will go to the high court for appeal. Special court, you have to go to high court for appeal. And when you see under the high court, you will have a lot of courts. They will be court of session or other courts. Now, all these various courts will come under the jurisdiction of the High Court. High Court can transfer the case from one court of session to another court of session. Like that, they can do many things within the court of session. The High Court has the authority to do these things with the court of session. So, this High Court has the power for this court of session. In the same manner, High Court has the power over the special court also. From one special court to another special court, the High Court can transfer the case. Like that, the powers are there with the High Court. That is what they are saying here. For appeal, reference and revision, the matters will be there with the High Court. High Court has the same power that it has over the court of session. That point they have given. Then whatever the proceedings that is conducted between this by the special court, in that what will happen? In that proceedings, the special court will be deemed to be a court of session. They will assume that special court is a court of session. Like that, they will conduct the proceedings, and they will consider it as a court of session or as a court of metropolitan magistrate or as a judicial magistrate of the first class. They will consider the special court in the same rank like all these court. And whatever the person conducting the prosecution means the person who is what we can say arguing against the accused, then he will be treated as a public prosecutor. He will have all the rights, privileges, everything will be in the same rank, similar to a public prosecutor. So this is the rank of the proceedings that is happening in the special court. Now we can see the different types of offences. We are having two types of offences. One is cognizable, another one is non-cognizable. When you see from police point of view, what is the meaning of a cognizable offence? They can do the arrest without the arrest warrant. What is a non-cognizable offence? This is not allowed. Police cannot arrest without the arrest warrant. Mandatorily arrest warrant is needed. So that is the meaning of a non-cognizable offence. So here, cognizable means they can do the arrest without the arrest warrant. Non-cognizable means they need the arrest warrant. After that only they can do the arrest. Now this is from the police point of view. Now these are the types of offence we are having. The non-cognizable offence. Most of the offence under the Companies Act are non-cognizable only. For example, you did not file the annual return properly, you did not file the returns, all the forms, everything you did not file properly. Because of that, the police cannot enter into the registered office and they can arrest the director. That is not going to happen. The police does not have the right to arrest the director just because of an offence under the Companies Act. Here also we are having one exception. Exception is the offence handled by the SFIO, Serious Fraud Investigation Office. We will learn about this in a detailed manner in the Inspection Inquiry Investigation chapter. Whatever the offence that is handled by the SFIO, these are serious economic offences. For that, we can treat it as a cognizable offence itself. There is no problem. Normally, any offence it is non-cognizable under the Companies Act, but this specific offence that is cognizable only. Now, non-cognizable. All the offences under the Companies Act are non-cognizable except 2126. This is the SFIO. Then court shall take cognizance only on the written complaint. Now we saw based on the police. Now when you see from the point of view of court, what is the point of view of court? What the court will do, I will tell you. So when you go to a court, first what they will do, when the police goes and they are telling that this person is there is a problem on this person, like that they are starting the trial in the court. Then what court will do? Court will first issue the summons. They will try to give you what we can say, an order to attend the hearing. They will tell you the hearing date. On that date you have to go to the court and appear. If you appear, there is no problem. Then if you do not appear, what will happen? They will give you a bailable warrant. What is the meaning of a bailable warrant? The police will come to your house or wherever you are, and then they will ask you to come to the police station. You are having two options. First option, you have to go into the custody of the police. Or second option, you have to sign a bond. In that bond, you will be giving a guarantee that you will appear for the next hearing. The police will come to fetch you, but if you sign a bond that I am giving a guarantee that I will appear in the next hearing mandatorily, then they will leave you. You have to appear in the next hearing. Then if you do not appear, then also, then they will give the non-bailable warrant. This is the one that is popularly called as the arrest warrant. When they give you an arrest warrant, you have to mandatorily get arrested and you will not be able to go out. You will be produced to the court by the police. This is called as the arrest warrant. You cannot escape from this. So this is the process that will be carried on by the court. First, they will summon you to hear the case. If you do not appear, they will give a bailable warrant. Then they will give a non-bailable warrant. Now this is the arrest warrant. If this arrest warrant is there, only then the police can arrest you for all the normal cases. But if it is a cognizable offense, the police can arrest you even without the arrest warrant. Now, from the court point of view, when you see, this entire thing will be happening after starting the trial. First, they will start the trial. Like, what is the meaning of starting the trial? They will take notice and then they will start the proceedings. All the procedure, they will start it. This is the meaning of starting the trial. The court can start the trial only if they get a written complaint. This, when they can get a written complaint, after that only they can start the case. That is in the case of a non-cognizable offense. In a cognizable offense, even without a written complaint, they can start the trial. So I hope you understood this. This police, they can arrest without arrest warrant, mandatory arrest warrant needed. That is the meaning of cognizable, non-cognizable. In court, when you see, even without the written complaint, they can start the trial. That is a cognizable offense. In a non-cognizable offense, they have to get the written complaint. After that only they can start the trial. After that only this procedure will start. Now, all the offences under the Companies Act are non-cognizable. So, only after the written complaint, the court can start the trial. Who will give the written complaint? Registrar, shareholder, member, person authorized by central government. So, we can add one more page here. So, this we can take it to the last. The complaint will be given by the registrar, ROC, shareholder or member, or person authorized by CG. These people will give the complaint. After that only they can start the trial. Now, if it is a listed company, even a person authorized by SEBI can give the complaint. So that also they have given here. Then, if a company wants to do a case on the officers, then this provision that is given above that will not be applicable. So this is for the thing to be done on the offense under the Companies Act on the company you want to do. Any offense that happens under this section, any offense that happens under the Companies Act, for that you can do this. But here when you see companies starting a case on the officers, for that you cannot apply this section and all. Then, when a complaint is given by registrar or person authorized by the central government, they need not appear personally. They can send their authorized representative also and they can give the written complaint. Then, any action taken by the liquidator, when a company is going under winding up process is going on. In that time, the liquidator of the company, they want to take any action against any person. For that, this section will not be applicable. Then the next thing when you see, Here, liquidator will not be deemed to be an officer. Liquidator is not an officer of the company. That also they have given. If you are starting a case against a government company, then only a person authorized by central government can give the complaint. That is one more thing, exemption given for the government companies. So this is the meaning of cognizable and non-cognizable offense that you can see it from here. That's all about the special courts. Now, before starting the next topic, I will just give you a small recap of the special court. So here, if you see what's the special court, they have given the establishment for the special court for the speedy trial of offences, and then offences to be non-cognizable. This topic alone we can see one more time. All the offences under Companies Act, it is non-cognizable, and court can take cognizance and start the process only after the written complaint. So who can give the written complaint? ROC, shareholder member, person authorized by the central government. ROC and person authorized, if they are giving the complaint, no need to appear personally. They can even send an authorized representative. If it is a listed company, then SEBI person authorized. They can also give the written complaint. So all the offences are non-cognizable under the Companies Act. Then, in some cases, this provision will not be applicable. What is the cases? So, non-applicability. First one, when a company is doing a case on its officers. Second one, when liquidator, when the winding up is going on, liquidator is taking any action. For that, this provision will not be applicable. And then, another thing, another point is that liquidator is not an officer of the company. Liquidator is not equal to the officer of the company. And another exemption that we had for the government companies. In case of government company, you have to take the cognizance only when person authorized by CG is providing the written complaint. So, person authorized by the central government. Now, that's all about the special courts. Now we can start the topic of compounding of offences. So here also we can add one page. We are having two types of offences. So under the compounding topic, we have to divide the offences into two categories. So first category and second category. First category, we have to see the punishment is imprisonment only. The punishment for the offence is imprisonment only, or imprisonment and fine. In these two cases, compounding not allowed. Then we are having other types like fine only, or imprisonment or fine, or imprisonment or fine, or both. So these are all the second category offences. So if this is the punishment, then compounding is allowed. You can do the compounding, there is no problem. What is the meaning of compounding? There is an offence. There may be two stages. Either prosecution started, like the case started. Prosecution not started. An offence is going on, prosecution started or not started. Now you want to drop the case. You want the government to drop the case. I will give you the money, just drop the case. Do not start any other case on this particular matter. On this particular violation, do not conduct the proceedings. Now, what you have to do, if it is a second category offence, you can go under compounding. What is compounding? You have to pay some amount. You have to pay an amount and the government will drop the case. They will not torture you anymore. You have to just pay the amount, they will drop the case. How much amount you have to pay, that will be decided by the tribunal. So that is the meaning of compounding. So tribunal can do the compounding, or when the offence, when the maximum fine is up to 25 lakh only, then regional director itself can do the compounding. Compounding can be done by tribunal. For all the cases, tribunal can do the compounding. If the fine is up to 25 lakh, then regional director itself can do the compounding. So I told you that you have to pay the amount, they will drop the case, no other proceedings will be initiated on this particular matter. Then whatever the amount you are paying, that will be maximum. The maximum amount how much they can say? The amount maximum that they can say, that is the maximum fine that is given in the section. Up to the maximum fine, they can ask you the amount, but beyond that, they cannot ask you. Then if against the company already some investigation is going on, against one company the investigation is going on and the company has done some offense, you want to compound it, that is not allowed. Already investigation is going on means you are not allowed to do the compounding. Then for example, we can add one more page here. So now you are doing an offense. This point of time, today you are doing an offense. You did the offense and then you did the compounding. You paid the amount and then everything went fine. Compounding successfully completed. Now we are having 3 years timeline. This is the end of the third year. Now in between itself you are doing the offense. You are doing the same offense or similar offense. So here if you see similar offense which is committed within a period of 3 years from the date of a earlier offense. So you are doing a similar offense. Then you will be considered as a repeat offender and for this offense compounding will not be allowed. Then you can say second case, after 3 years you are doing a similar offense. Then this will be treated as a first offense. There is no problem. Up to 3 years is the timeline. For 3 years you have to stay silent. If you do a similar offense again, compounding will not be allowed and you have to face the consequences. After 3 years, whatever the offense you do, it will be considered as a first offense only. So that provision they have given here. Then you have to file the application for compounding to the registrar. So what is the process? Step 1, you have to file the application to the ROC. Step 2, after that what will happen? Registrar will forward it to the tribunal or the regional director. So it will go to the tribunal. Then after that what will happen? The tribunal or regional director, they will decide whether they have to do the compounding or not. And if they complete the compounding, they successfully order the compounding, have to pay the amount that is decided. Then what will happen? The company should give an intimation to the registrar within 7 days from the date on which it is compounded. They have to give the intimation to the registrar. Tribunal or the regional director will decide, and if the offense is compounded, you have to give the intimation. Intimation to ROC. What is the timeline? 7 days. Now, where an offense is compounded and no prosecution is started till now, no case has been started till now, then in the future also you will not start any case. If already a case has been started, then you will drop all the proceedings that they have written, that they have given here. Then an offense is there. What is the offense? You have to file some return, file some document. You have to file the annual return, do this thing, do that thing, like that. Some document filing is there in the offense. Then the tribunal will specify in the order that file the document within 30 days and then pay this amount, the compounding will be done. Then you have to properly file the document within that date. If you do not follow the order, if you contravene the order, if you violate the order, then the fine will be considered twice the amount. For example, the maximum fine is 1 crore. Then if you violate the order, the fine will become 2 crore. So if there is an offense where imprisonment only or imprisonment and fine written, then it is not compoundable. That I already told you. So this is the main points relating to the compounding. So category 1, category 2 offense, you have to pay the amount, government will drop the case. If up to 25 lakh, RD will do the compounding, otherwise tribunal will do the compounding. Maximum amount is maximum fine only. Up to 3 years you are doing a similar offense, then it is what we can say, compounding is not allowed. After 3 years if you do, it will be deemed to be a first offense. Step 1, ROC application. Then step 2, it will go to the tribunal or regional director. Then if the offense is successfully compounded, then within 7 days you have to intimate it to the ROC. The same thing they have given here also. Now we have completed the topic of compounding of offences. Now we can start the next topic, mediation and conciliation panel. Not all the cases we can send them before the tribunal, central government and all, and special court. And we have to do the mediation also. Sometimes when you do the compromise, some people will get compromised and then the proceedings will be dropped. They will go on a mutual benefit, like mediation, conciliation. You would have studied in the SETC arbitration itself. I would have told you about that. Now here, for that we are having a mediation and conciliation panel established by the central government. Their experts will be there. Then any case which is pending before the central government or any case pending before the tribunal, any case pending before the appellate tribunal, that is central government, tribunal, appellate tribunal. If any case is pending in before of these three forum, then that case can be referred to the mediation and conciliation panel and they will try to solve the case amicably. If you want to do on your own, you are a party to the case, you want to start the mediation, you want to go to the case to you want to refer the case to the mediation panel, you can apply to the central government or what we can say, tribunal, appellate tribunal. Then the persons, the central government, tribunal, appellate tribunal, they will refer you to the mediation and conciliation panel. And central government or the persons if they want to suo motu, like on their own they want to refer some case to the mediation conciliation panel, that also they can do, either on the application of the party or on their own. Central government tribunal, appellate tribunal, they can refer a case to the mediation conciliation panel. And fees, what all the other terms and conditions for the mediation conciliation panel experts, everything will be in the rules. The mediation conciliation panel, they have to complete the work, they have to solve the case within 3 months. If it is not solved within 3 months, then it is not over and we have to go to the normal procedure. Within 3 months is the time for the mediation conciliation panel. They will be creating some recommendation. Recommendation means like this is the method to solve the case. This person has to do this, this person has to do this, then we can solve the case amicably. Like that, they will give the recommendation to the central government tribunal, appellate tribunal. And if there is any person you are having a problem with the recommendation of the mediation conciliation panel, then you can file the objection with the central government tribunal, appellate tribunal. Nothing but they are having 3 months time. They will give the recommendation. The recommendation, if you are having a problem with the recommendation, you can file the objection. That's all. So that's all about the mediation and conciliation panel. Now we can go to the next point. Serious Fraud Investigation Office. Central government will establish the Serious Fraud Investigation Office. This is for a specified offences. When the central government feels that it will be proper when SFIO is investigating the offence, then they will refer the offence to the SFIO. SFIO, they will have their own procedure. They will be appointing an inspector. They will be doing the investigation. Everything we will be doing, and that we will be seeing in detail in the inquiry, inspection, and investigation chapter. Now here, if you see, when registrar is giving a report for a particular offence or special resolution passed by the company, and they are giving a report for an offence or public interest, or even a request is given by the Department of Central Government or State Government, in those cases the central government can assign the problem to the Serious Fraud Investigation Office. They will assign the investigation to that agency, and then they will do the, what we can say, investigation. Now the next point is power of central government to appoint the company prosecutors. So we know public prosecutors. Public prosecutors, they will be appearing for the government. They will be the one, they are getting the punishment and giving it to the criminals or the accused. So these are called as the public prosecutor. These are general people. General means they are lawyer only, but they are not specialized in company. They are advocates, they are not specialized in company law. But central government, they can appoint some public prosecutors as the company prosecutors. They will be specializing in the cases related to the Companies Act. So central government will appoint them, and they will be acting as the company prosecutor. They will have all the powers, privileges that are there with the public prosecutor. Then acquittal. What is the meaning of acquittal? So we can add one page here. So what is the meaning of acquittal? So you are filing a case with the court, and then court will give the judgment. Either the person is guilty or the person is not guilty. Now, this not guilty judgment, that will be called as acquittal. This means that the person is a clean person. Like in audit, we will give the unmodified opinion, which is also called as the clean opinion. There is no problem with the financial statements. Everything is proper. It reflects the true and fair view of the state of affairs of the company. Like that, we will give the clean opinion. In the same manner, the court will give a clean person declaration. That is called as the acquittal. Now, the accused will now be called as the acquitted. Earlier, when you filed the case, he would be called as the accused. Accused means the person on whom you have told the allegations. Now, after the judgment, he will be called as acquitted. Now, the government filed a case, and then the person came acquitted. The company, and then the person got acquitted. The central government, they can go for an appeal on the higher court. They can file an appeal, and they can try to give the punishment to the acquitted by going on a higher court. So that is what they have given here. When a judgment of acquittal is passed, the company prosecutor or any other person will be appointed by the central government, and they can go for an appeal on the higher court. Then you filed a case on some person, and then he got acquitted. Now this acquitted, he is having some right. What right he is having? He is having the right to get some compensation. He did not do any wrong thing, but you filed a case and you dragged him to the court, and then now he got acquitted. In this meantime, he got some loss of money, loss of time, emotional damage, everything happened to the acquitted. So he has the right to compensation. He can also file the right to compensation there. Then whatever the fine you are collecting, that will be used for the payment of cost of the proceedings, and then it will be given as a reward to the persons. So, like we will have some persons who will be giving the information. In one company, some board of directors will be there. Some directors, they will be doing some illegal things. Then good director, Like the good director in the company, they will give the information to the government or the investigating agency. They will be called as the person who's giving the information to this good director. We will give the amount as the reward, whatever the amount or fine we are collecting. Then how much punishment we have to give? For example, minimum fine is 1 crore we are having, maximum fine is 25 crore we are having. How much punishment we have to give? 1 crore, 25 crore, or in between some punishment we have to give? That will be decided keeping into mind the size of the company, how much big level of a company it is, nature of the business, what business they are doing, injury to the public interest, how much damage that has caused to the society, nature of the default, whether it is a serious offense or a minor offense, repetition, they are doing it for the first time or they are doing it for the multiple times and this is the third or fourth time. This all they will keep into mind when they are deciding the level of the punishment, either the fine or the imprisonment. Then, when you are 1% company or a small company, you cannot give this much penalty and all. Even if it is 25 crore, which is mentioned in the act, you cannot give this much penalty and all. So, therefore, they are giving one more option to you. If you are a 1% company, small company, producer company, startup company, specified companies, 1% company, small company, startup company, or producer company. If you are coming under this category, you are getting a lesser penalty. What is the lesser penalty? Up to half of the penalty. If it is given as 50 crore the penalty, then half, that is 25 crore will be the maximum penalty for this category of companies, and subject to maximum 2 lakh rupees in case of a company and 1 lakh rupees in case of a officer. So for company it is maximum 2 lakh rupees, and then for officer in default it is maximum 1 lakh rupees. This is the half of penalty. We will take half of penalty and then we will see if it is coming up to 1 lakh or 2 lakh. Even if it is coming more than 2 lakh, we will take only 2 lakh or 1 lakh only. For company, maximum 2 lakh they can give. Officer in default, they can impose a penalty of maximum 1 lakh for these specified companies. That also they have given here. Then adjudication of penalty. There will be adjudicating officer. They will be appointed by the central government. They only will decide how much penalty should be given. That is the next topic. Now we can start the topic of adjudication of penalties. So we can add one page so that it will be comfortable to write. Now we saw that central government will appoint the adjudicating officer. Now one more point is that they will be not below the rank of the registrar. All the adjudicating officers will have the same rank as the registrar of companies. Then when you see what will happen, first the adjudicating officer, before declaring the penalty, they will give you a notice. So step 1 is notice. You will be getting a notice. That notice who will be getting? Company, officer in default, any other person, everyone will be getting the notice. So that is not that much important. So company, officer, any other person, everyone will get the notice and then they will give the time period. In the notice, they will mention the time period. Within this time period, you have to give the reply. The time period will be minimum 15 days to maximum 30 days. Within this time period, you have to give the reply. Then, in the notice, what will be there? That is one more point. The content of the notice. It will contain what default you did or what non-compliance you did. Then, what is the penalty for that? And they will also mention the maximum penalty. Under this provision, they can give a penalty of up to 2 lakh, up to 3 lakh, like that. They will also mention the maximum penalty. This should be mandatorily there in the notice. So that provision they have given here. Draw attention to the penalty provisions and give the maximum penalty also. Then, period of filing the reply. Within the time period, you have to file the reply. Within the time period, you have to file the reply. And they can also give you an extension. Extension for the time period. They will give you extra 15 days. So that you can file the reply. There should be sufficient cause. There should be proper reason. Only then they will provide you the additional time, extension time. Physical appearance. Now, after considering your reply, you gave a reply, right? After reading that, the adjudicating officer thinks that you need to appear in person. So this is done. Step 2. If they want, they can ask you to appear in person. They will give you the date and you have to go and appear in person. You have to explain what is the problem, what is your side of the case, that you have to tell to the adjudicating officer. And this is the demanding of appearance by the adjudicating officer. We are having one more method. In that method, you also can go voluntarily and appear before the adjudicating officer when you are filing the reply, right? In that reply, you are demanding for an oral representation. What is the meaning of oral representation? You are saying that I will appear personally and I will explain my argument. Like that you are saying to the adjudicating officer, they will give you a date. On that date you have to appear and give your representation orally. After hearing your reply, after hearing your representation on the date of appearance, after that they will give you an order. What order? They will give the final order, or they can give the order for adjournment, for postponing the case. The next hearing will be conducted on this date. Like that they will give you an order for adjournment also. On the date fixed for hearing, they will give you the proper opportunity to present your argument. After that, they will give the adjournment order or the final order. After the hearing, the adjudicating officer can also ask you to submit your reply in writing. So, step 3. They will give the order, which may be either final or adjournment. They may also ask you to submit a reply in writing. Whatever you told in the hearing, that you have to submit in writing also. Like that, the adjudicating officer can give you an order. So that is done. The next thing, when you see period for passing the order. Now physical appearance done. If physical appearance is done, you have to take 90 days. So what is the maximum time period that can be taken? Maximum time period in the case of no physical appearance, and then physical appearance is done. In this case, it is 90 days. 90 days from the date of issue of notice, from the notice date. From the notice date, 90 days. Where physical appearance is not required, 30 days. 90 days where physical appearance is needed, 30 days where physical appearance is not needed. So this is the maximum time period. This is also one important point. Then the next thing, when you see on the order, it will be dated and it will be signed, and then they will be giving the reason also why they wanted you to appear personally. They will give the reason for the physical appearance also. They will forward the order to the company, officer in default, other person, or all of them, central government. It will also be uploaded on the website. So these are all the publication of the order. The order, they will communicate it to these people. The authority, what is the power of the adjudicating authority? They can summon and enforce the attendance. They can mandatorily compel you to attend on the date of hearing physically. They can demand your attendance. They can order you to provide the evidence, or they can demand the evidence from any other authority, any other officer, any other government department. They can ask them to produce the evidence document, or any other person. They can get the document produced by demanding it. Then, if a person does not comply with the order, they asked you to appear personally, but you did not appear, then what will happen? They will impose the penalty. After that, when they are giving the penalty, what they will see? They will see the size of company, nature of business, injury to the public interest, nature of default, repetition, and here this is the new point. Amount of disproportionate gain or unfair advantage. For example, you did something like violation and you got some advantage. You earned some profit. How much profit you earned? How much gain? How much unfair gain you earned, that they will see. And then amount of loss caused to the investor because of your non-compliance or default. If there is any loss caused to the investor, how much loss they got, that also they will see when they are giving the penalty. Next thing, fixed sum of penalty. For example, in this section, they have given a fixed penalty like 10 lakh rupees is the fixed penalty. Then that penalty will be imposed by the adjudicating officer. They have to pay the penalty through the MCA portal. That is all given only. All the sums will be credited to the Consolidated Fund of India. All the amount you are paying, that will be going to the Consolidated Fund of India. Then the next thing, adjudication platform. They have created a e-platform, that information and all they have given. You can read it by yourself. The next thing, the central government, when they are appointing the adjudicating officer, they will tell the jurisdiction, like up to this area, this territory will be under your control. Like that, they will appoint the adjudication officer for every jurisdiction. That area of coverage will be under the purview of the adjudicating officer. Then for the other area, another adjudicating officer will be there. Then they will impose the penalty on the officer in default, any other person. They have to pay the penalty. They can direct such company to rectify the default. For example, they have to do some filing work, that the tribunal can give the order to instruct them to do the filing, complete the filing within 30 days, and then they will give the penalty. So that also they will give if there is any pending filing or some incomplete work. They can rectify the default. In that case, they will order the company to rectify the default, to make right the default. And this is one more important point. So you are getting the notice, right? From the date of notice, 30 days, or prior to the date of notice. You know that you have did an offense, and prior to the date of notice or within 30 days from the date of notice, you rectified the default. Like you completed everything, you did some payment or whatever is the non-compliance, you rectified it. Then no penalty will be imposed on you. This is one important thing. Even if you do the offense, you are getting the notice. After that, within 30 days, if you rectify it, there will be no penalty levied on the company or the officers. Next, before passing any order, they have to give the opportunity of being heard. That and all we saw. Then you can appeal to the regional director. So this is one more important point. From adjudicating officer, you can go to appeal to the regional director. Appeal to the regional director. Then appeal you have to do within 60 days. Then regional director also, they will give you an opportunity to present your case. After that, they will give the order. They can confirm the order, modify the order, set aside the order. Everything is same. If the company does not mandatorily properly follow the order, either the order passed by the regional director or the order passed by the adjudication officer, then they will be giving a fine. The company will be punishable with a fine, which shall be minimum 25,000, maximum 5 lakh. So fine will be 25k to 5 lakh. Then if the officer or any other person, they do not comply with it, then also within 90 days you have to implement the order, you have to do the work properly. Otherwise, you will get imprisonment. 6 months up to 6 months. Imprisonment up to 6 months. And fine you will be getting minimum 25,000 rupees up to 1 lakh rupees, or both. Imprisonment or fine or both. So this is the thing here. If you are not following the order given by the adjudication officer or the regional director, then repeated default. If you are doing a repeated default, then 2 times the amount of penalty will be given. So that also they have given here. When you are going to the appeal to the regional director, 60 days you are having the time. That also we can note it above. So this is the entire provision of the adjudication officer. So now we have completed the entire chapter of the NCLT, NCLAT, special courts, adjudication and compounding. All the topics we have covered properly. So chapter number 9 is done. If you learned from this video, you found this video useful, you can subscribe to the channel, like this video, share this to your friends so that they will also get benefit from this. And then the notes will be uploaded in the website and you can download it from there. All the best for your exams.